Good morning. It's 9 o'clock this Tuesday, May 12th, 2020. I'm calling the Blanco County Commissioners Court to order. Ms. Waller, will you call the roll?
Judge Bray.
Here.
Commissioner Weir.
Here.
Commissioner Eaker.
Here.
Commissioner Leisman.
Here.
And Commissioner Redbird.
Here. Please join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Commissioners, there are 3 public comments forms submitted this morning. The first will be Deanne Welch, Peyton Colony Road, wishing to speak on agenda item 9. Well, while we wait to try to figure that out, maybe we can move to Mr. Kasparis. Is he online? Well, they're unmuted, but are you unmuted? Are you able to use the chat function to type messages to them? Take whoever you can get.
Mr. Welch, you ready? Or excuse me, Mrs. Welch, are you ready? Yes. Okay, you have the floor.
I understand motion for this to be on agenda item number 9. Rules of procedure for this commissioner's court was last considered in July of 2019 after the legislature clarified the intent that the public shall be welcome in political processes. The addition of section 551.007 to the governing rules stipulates a governmental body may not prohibit public criticism of a governmental body. I have attended nearly every commissioner's court meeting since last July when you last amended the rules, and I have witnessed no examples of abusive public comments being offered during your typically brief final deliberations. Thus, I've been at a loss to understand why you believe it's necessary to amend the rules again, less than 1 year since the last amendment, and particularly why you now would seem to fear oncoming abusive public comments. Although I and others have publicly criticized this commissioner's court regarding inadequate emergency response, unsafe roadways, naivete in pipeline negotiations, and a general failure to welcome public participation, it would be unwise to characterize such criticism as abusive. I also note that you wish to insert the adjective repetitious into the series of enumerated language types which shall be prohibited. Thus, I believe it is important for me to note at this time, and for the public record, that quality such as repetition is ambiguous and subjective and would be indefensible if utilized to prohibit public criticism of this governmental body. My experience with this governmental body has been that you will not communicate yes or no as to whether you will communicate. And you cannot represent without communicating. You do not respond to emails. Judge Brady, do not grant attentiveness as up at you from the podium. You shuffle papers and otherwise distract to such extent that the recording becomes inaudible. Your staff does not respond timely or without being prompted to do so by the Attorney General's office to request for public information, and I do not believe you faithfully honor the open meetings laws. I have been and intend to continue publicly criticizing this governmental body for failure to secure fully staffed and fully funded emergency services for all of the people of Blanco County. And as we move into budget negotiations in upcoming weeks, I intend to repeatedly note that every considered expenditure, every salary, every slush fund imaginable is of lesser importance than securing the safety and security of Blanco's citizens. Now that you know my plan, future budget negotiations, how should we proceed?
Connie, is Mr. Welch prepared?
Mr. Welch, are you ready, sir?
I am.
Okay, the floor is yours, sir.
I, Kenneth Wells of Blanco County. I have read the proposed amendments to the pipeline easement and master road use agreement. I thank you for reopening this matter. However, as usual, there are deficiencies in the terms negotiated by the representatives of this court. Item number 4, Texas Railroad Commission is requiring 2 weeks' notice prior to trenching or boring underneath roadways.
Let's move to Mr. Casparis, please.
Good morning. I support the new conditions specified in the supplemental agreement to the pipeline easement and master road use agreements with Kinder Morgan. However, in light of the boring incident on March 28th, which polluted several wells, these revisions are not specific enough and do not go far enough. On March 16th, John Watson, Peter Devine, and I sent a letter to the judge and commissioners recommending specific actions to be added to these agreements. The county has not adopted any of these. Blanco County should share the Railroad Commission's concerns that resulted in a formal notice of violation of statewide rules, including Rule 8B. The loss of drilling fluid resulted in the pollution of fresh surface water, and Rule 20A, immediate notice of the event was not provided. It took Kinder Morgan 3 days to report the incident to the Railroad Commission. This failure by Kinder Morgan demonstrates that they cannot be trusted to show reasonable judgment. Therefore, Item 5 of the supplemental agreement related to any reportable spills, accidents, or significant law enforcement activity should require an immediate work stoppage and a specific time frame for notice to the county. We recommend notice within 1 hour. I'll summarize our original recommendations. We recommended that Blanco County should not allow any road work until Kinder Morgan has complied with the Railroad Commission notice of violation. 2, that any revised plan allowing Kinder Morgan to proceed in a manner that will prevent further impacts to groundwater be incorporated into the county road agreement. 3, Kinder Morgan be caused to show proof that they understand the geology at these crossings, including voids, caves, and karst structures, to reduce the chance of further pollution of groundwater. And 4, that owners of private wells within a 1-mile radius of the crossings and the groundwater district be notified in advance of the start of work. Why would Blanco County not take these precautions? Why would the county revise this agreement before all the facts are known and the Railroad Commission has accepted Kinder Morgan's revised plan? I cannot think of a good reason other than Kinder Morgan's schedule. From the beginning, I and others have asked the Commissioners Court to show concern for Blanco County citizens and leadership in holding Kinder Morgan accountable. Your reply, in general, has been that you have no authority over pipelines. Now the risks have been clearly exposed, and you have the authority and the duty to assure that crossings of county roads do not create additional problems. Please reconsider this limited supplemental agreement and do the right thing for our citizens. Thank you.
Commissioners, item 4 involves review of and possible approval of 2 sets of minutes, one from the last meeting in April and the other from an emergency meeting just shortly thereafter, up for your review.
I'd like to make a motion to dispense with the reading of the minutes and accept it as presented for the dates: special meeting April 28th, 2020, and emergency meeting April 29th, 2020.
Is there a second?
I'll second it.
Commissioner Weir seconds. Discussion. All in favor say aye.
Aye.
Opposed? Motion carries. Item 5 involves the estimated payroll for May of 2020.
I'll make a motion to approve the estimated May 2020 payroll in the amount of $438,940.39.
Commissioner Granberg seconds. Discussion. All in favor say aye.
Aye.
Opposed? Motion carries. Takes us to item 6, the official reports. And they are, it's been reported that they are all in and available for public inspection and subject to your approval. So, If we could get a motion to approve
We
the,
approve the official reports as presented.
is there a second?
Second.
Commissioner Leesman, discussion. All in favor say aye.
Aye.
Opposed? Motion carries. Next are line item transfers, and I believe there are three, I see two of them, excuse me. Two of them for you to ratify, both involving precinct, well, sorry, one involving precinct 4.
I make a motion to ratify and approve the line item transfers as presented.
Mr. Granberg seconds. Discussion. All in favor say aye.
Aye.
Opposed? Motion carries. Item 8 are the outstanding bills for the county for the month.
I make a motion to approve the outstanding bills in the amount of $56,796.81.
I'll second.
Commissioner Eaker seconds, I think. Is that right?
Yes.
Okay. Discussion. All in favor say aye.
Aye.
Opposed? Motion carries. Item 9 involves your review and possible updating of the rules of procedure and conduct for the meetings. This was prepared by the county attorney's office at my request. On the second page in subsection E, the word repetitious has always been a policy and on the agendas since the beginning of public comment at the Commissioner's Court, but it wasn't in the actual rules. And so we're trying to conform the rules to practice and policy. And then the other addition was added by the county attorney's office based on case law and current practice. I think this may even be a recommendation from the County Judges and Commissioners Association. Those are the only two changes I remember or see, and they're subject to your consideration.
I make a motion to approve the updated version of the rules of procedure, conduct, and decorum at meetings of the Blanco County Commissioners Court.
Is there a second?
Second.
Commissioner Granberg, discussion. All in favor say aye.
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 Opposed? The annual investment policy, by its very title, annual, needs to be reviewed and possibly approved by you all at this time.
I make a motion to approve the Blanco County investment policy as presented.
Is there a second?
I'll second.
Commissioner Eaker, discussion. All in favor say aye.
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 Opposed? Motion carries. Next on the list or the agenda is item 11, which involves the Motorola Services Agreement. Commissioner Leesman.
Yes, sir. This is the annual agreement that we do with Motorola to service the software and firmware within our tower sites. And I make a motion to authorize the county judge to sign the annual Motorola service agreement for FY 2020 through 2021.
Is there a second?
I'll second it.
Commissioner Weir, discussion. And looking at the numbers, I haven't checked yet. Is this within our budget, or is this for next year?
This is for next year's budget. It'll be budgeted out of the next year's budget.
So the commissioners need to be aware that we'll need to be budgeting for this.
Yes. But it's also part of the service agreement that we do with the 3 counties in the city of Laurel Falls. So that's how it gets paid out of that.
Anything else? All in favor say aye.
Aye.
Opposed? Motion carries. Item 12, the letter of credit for the Trinity Oaks subdivision. Do you want to say something? Or?
So this is one that I personally disagree with. This is a flaw in the system. Since this subdivision is it's a TCEQ approved water supply, then we cannot keep them in the building construction maintenance or bond just because that hasn't been completed. So our bond is only on the roads and the drainage and things of that nature. It doesn't have anything to do with the water system. So I'm not a big fan of that, but that's the way it works, and that the opinion came from the county attorney's office. So with that being said, the roads have been completed, the street signs are in, all the drainage has been done, the water lines and the electric utilities, all that's been installed. So I would like to go ahead and make a motion to move from the construction bond to the maintenance bond for the Trinity Oaks Preserve subdivision.
Is there a second?
Can I ask a question right quick before we second? Does TCEQ still have some oversight into it to make sure that that gets done? Do they have their own bond, or how do they guarantee that that gets done?
That is it falls over to TC. It's in their hands. It's not in our. We have no authority over it.
And there's really, you don't even know the time frame on it. I got you.
Exactly.
Wow. That's all I need to know.
Still looking for a second.
I'll second.
Commissioner Weir seconds. Discussion. So the statute in question unfortunately does just limit us to bonding road and drainage improvements. There is another, I think where other counties may have gotten confused, and the reason I say it that way is because we took our model rules and we adapted them from some other county examples. And I think other counties have been confused because they have it in theirs that you can bond basically water provision, water development improvements. It appears from the statute that it's a separate subsection that does allow for that, but only in counties along the border. So we're not included. There is language in the local government code that would work for us if it applied to us, but it does not presently. Maybe that's something for a legislative change, because it seems to me appropriate that in these subdivisions that we're having to approve the plats of, it would be nice if the bond also covered all of these kinds of major improvements that are going to apply to the subdivision as a whole.
I agree, and I guess my hardest feeling is we allow, with the TCEQ, this subdivision fell in the old subdivision rules and regulations. And with the problem of we're allowing them to drop down the acreage size to allow for only a private septic, but yet I can't make sure that they complete their water system. So if he sells the lots and then he bails, then of course he assured me that he won't. But we have no recourse. Who are the people that just bought that property? Who are they going to come complain to? It's going to be us. So, but according to the county attorney's office, I can't change it. So it is what it is.
The only reason I second it is because I understand the limitations that the county has.
And now let me keep in mind though that the maintenance bond, the amount of the maintenance bond is actually greater than the amount of the construction of the water system anyway. So, but it could
True, but we can't use it for the water system.
So anyway.
And really, just for the purposes of the recording, this discussion is kind of broader than Trinity Oaks Preserve. It's about subdivision development in Blanco County in general.
Correct.
Sure.
All right. Any other discussion on this? And yes, sir, I think thank you for seconding, because I think you properly characterize it as we're obligated at this point to do this under the law.
Sure.
Anything else? All in favor say aye.
Aye.
Opposed? Motion carries. Okay, 13. The supplemental agreement for the pipeline easement and master road use agreement between Blanco County and Kinder Morgan. We had, in the past couple of weeks, we've had a couple of incidents or situations where we, particularly Commissioner Weir and I, became concerned about full and complete compliance under our agreements, and we called that into question, negotiated with Kinder Morgan, and came up with some additional language to supplement the original agreements that you approved. The idea being to give we thought it said so in the first place, but this language is to clarify better access to information and access to sites by commissioners, and other personnel that commissioners designate. Is there anything you want to say to that before we look for a
No, sir,
motion?
that's pretty much it. We just needed clarity.
And would you mind reporting to the court since the day we met about these possible provisions, how it has been proceeding since?
Sure. If you look in the agreements, that we get a morning report every morning from Kinder Morgan. It tells us the status of the workers in the line, what they're doing, the welders, the epoxy crews, or whatever is out there. We get that every morning, 7 days a week now. We have access to the pipeline at any point in time. Any of the commissioners or the judge can go out and review it. If we need to take an additional inspector with us or whatever, we can. We have since been out there and reviewed it and been with them. We've seen the third-party oversight that's involved in this project and the way that they're doing it. And so now I feel like we're getting day-to-day information from them that we used to not get, and where they are throughout the whole county. So I feel a lot better now that we have that communication open, to where we should have been doing that all along in my mind, and we're there now. So with that, I feel better about it. I feel better about what they're doing and when they're doing it. And they should be keeping us updated on even the problems that are pending with them, and in a daily basis, to where see when those get resolved and which direction they take from there.
So, any other thoughts on this supplemental agreement? Anyone willing to move to approve this?
I would like to make a motion to approve the supplemental agreement to the pipeline easement and master road use agreement between Blanco County and Kinder Morgan.
Is there a second?
Second.
Commissioner Leisman, discussion. All in favor say aye.
Aye.
Opposed? Motion carries. And then item 14, which is concomitant to item 13, involves the investment agreement. The ultimate dollar figure, the total remains the same. The distributions are a little different. You'll notice we've included the public libraries. We've included the ministerial alliances. I didn't know there were two in the county. I thought it was one, but I have learned in this process that there's one for South County and one for North County. We equalized the payments for the two emergency services districts. The South District's getting a new generator for their brand new building out of the process, but the North District has an equal number of issues. The fire department that's being built in Round Mountain is probably in need of a little extra infusion. So there's uses for the money, and we just rerouted some of it for that reason. If you have any questions, I'll try to answer them. But Otherwise, I would hope for your motion to approve the amendment.
I'll make a motion to approve the amendment to the Blanco County investment agreement with Kinder Morgan.
Is there a second?
And I'll second it.
Commissioner Eaker, discussion. All in favor say aye.
Aye.
Opposed? Motion carries. So item 15 involves the annual road reports, and and as you can see, it says commissioners ×4, so it's each of you. I'm assuming that this is coming up because of our recent desire to and an activity with Allison Bass to submit an application for some grant funding through TxDOT. Am I wrong about that? Okay, so what do we want to say about the discussion and possible action on the annual road reports? Ms. Harrison, you collect them? Is that how it works?
Yes, they are turned into me on an annual basis. Actually, this would be the first time, to my knowledge, since being in this office, that of them going before court. They are required on an annual basis, as what we recently found out from Capital. And this is one of the steps in the process of the grant application.
And how is it going?
Actually, it's going very well. I believe this afternoon we should have all the paperwork ready for Mr. Wagner to submit the application.
So that means that the 4 annual road reports are in?
Yes, they're all in, and they're all in your packets. And this is, I believe, the last piece that we are waiting on in order to file our application.
I didn't see them in my packet, but so this discussion could be about if you all want to take shots at each other's reports, or I'm not sure what.
So I would like to make a motion to accept the annual road reports from each precinct, file them in the minutes, and submit to the grand jury with a copy of the road work contract for the past year during the 9 months of the county fiscal year.
I'll second that.
Commissioner Weir seconds. Let me ask you about that. You're reading kind of language that comes right out of the statute, but I thought that the submission to grand jury and stuff that doesn't apply to this county.
So if it doesn't apply to this county, then just file within our minutes.
Okay.
But if it does apply, then according to this, that's what it's.
Okay. I wasn't sure. I guess I'm not 100% sure that we're classified as a county that's required of. If it is, but I think that's fine.
Okay. So either if we're required to file with the grand jury, then we shall file.
Okay.
If we're not required to file with the grand jury, just file within our minutes.
And I'll second that.
Great. Other discussion? Concerns? All in favor say aye.
Aye.
Opposed? Motion carries. There was a little rain this morning, but item 16 is a burn ban for your consideration.
We do have a pretty good chance of rain Friday night through Saturday, so please be prepared for any flooding that might occur.
Yeah.
Without a pass on burn.
Well, and speaking of rain, it's not on the agenda, but it does qualify as a matter of community interest. Do you want to say something publicly about the testing this morning?
We are currently holding COVID-19 testing in the Blanco ISD, the high school in Blanco. We've had 39 registrants already, and you can sign up during the day and get registered to take the test, or to get tested if you prefer. And the numbers are on our website, on our social media, and the flyers
posted the results and everything from the one that was done in Johnson City,
The
right?
one that was done in Johnson City, we tested 94, and we came back with 94 negatives.
All right, so takes us to item 17.
Make a motion to adjourn.
Is there a second?
I'll second.
Mr. Granberg, discussion. All in favor say aye.
Aye.
Opposed, motion carries. We're adjourned.
I think